I'd like to call the committee of the whole for the Village of Cary for Tuesday, April 17th, 2018 to order with roll call, please.
Kraus.
Here.
McAlpine.
Here.
Betts.
Here.
Kostler.
Here.
Weinhammer.
Here.
Cavelli.
Here.
Thank you. Would you join me in the Pledge of Allegiance? I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
We'll now open it up to public comments. Does anybody have anything they'd like to share with the committee of the whole? Please come up to the podium. He's bringing it to me as we speak. Thank you. If you could just state your name and address for the record, please.
I'm Mary Hall, and I'm at 937 Woodbridge. Just wanted to say, and for each of you to know, and for the chief to know, and anyone else who lives and works here, how I just moved here recently, and how pleased I am at the lovely way I've been treated and helped. People, the chief, one of the chief's men, Jeff Highcorn, who I've already talked to him about, went out of his way to help me with an issue. And also John Fitch, who's the head of the code enforcement, was sensitive and thoughtful and very helpful, and again went out of his way and on his own time to help me with the same issue. So really want to put the word out. I'm so thrilled by the graciousness and the love that I've received since I've come here. Thank you.
Well, thank you very much for sharing that with us.
How nice.
Okay, thank you. Anybody else? All right, we'll go ahead and close open forum. Just give that to Jake. Thanks. We're going to have a discussion again on the solicitor's ordinance. Chief, I'll turn it over to you.
Thank you, sir. I just want you to know that I had to up my game here because Director Morimoto set the bar high, so I had to do a PowerPoint presentation, and it doesn't like me now. This one? There you go. All right, thank you.
Teamwork.
That's, it's being temperamental. So anyways, what I'm going to be discussing here is, number one, the current ordinance that we have and those things that are particular to solicitors functionally or operationally, and then some of the issues that manifest themselves as it relates to, there you go, as it relates to some court decisions that go back to 1961 in River Forest. And when you look at our code, you kind of recognize that there's a reason why certain things were written in certain ways in the code. So just so you know, the police department is responsible for registering all solicitors. They have to submit a written application. They have to answer some questions related to if they had a felony conviction in the last 5 years. They have to provide some information related to their personal identifiers, and then they have to submit information related to the entity that they're soliciting for. We have to keep those records, and we do that. We process over 100 solicitor registrations annually. Although that sounds like a big number, understand that we issue solicitor permits 30 days at a time. So we do have some individuals, one in particular that submits 12 of them a year. He works for a local remodeling company, and he does soliciting throughout the year. So he'll submit 12 of them for each month. In regards to complaints that we've received relative to solicitors, generally it's between 40 and 50 a year. I couldn't give you a 2017 data right now because we're having some issues related to our CAD data. But I was able to go back 14, 15, 16, and you can see there that in 14 we had 45, 15, 40, and then 16, 50. Now, in regards to violations that we cited in 2016, we had 1 violation. In 2015, we had 4 violations, and one of those, actually 2 of those violations resulted in me revoking their solicitor permits or their registration, and then 2 violations in 2014. This is the current ordinance as it relates to soliciting, and the definition. And you can see here that soliciting means anything involving 1 or more of the following activities, and it's for any consideration whatsoever. There's door-to-door contact or the use of flyers or types of literature left on residential porches. We'll talk about that in a little bit later. But I indicated in red that it accepts out sales of books, periodicals, and other publications or subscriptions to such. We're going to talk about a decision that occurred in River Forest related to a person looking for subscriptions to a newspaper. They were cited under a similar ordinance, and the decision was that freedom of the press prevails, and yeah, you had to exempt out people that were related to issues involving the press from soliciting. So that's the first thing that, yeah, you look at this ordinance and you say, okay, well, there's a reason why they exempted that out. Second thing is if someone's peddling insurance, and then the third thing is looking for anything of value, you know, gifts or contributions of money, clothing, other valuable things, going door to door, or soliciting on a roadway or on public property. Remembering, of course, I'm saying public property because occasionally we'll have certain groups that set up in front of private property, you know, stores, restaurants, things of that nature, and that's not necessarily governed by this particular ordinance. Who has to register? And it says every person. That's our current ordinance, every person, and they're required to make a written application for a certificate of registration. Comes to my office, I look at it, I approve it, and then we issue it. This is very important. I've said this before when we have discussions related to solicitors, and this is our policy that's in the current code related to soliciting, and that is that it is the occupant in the municipality that makes the determination whether or not solicitors shall or shall not be invited to their respective residence. When we start talking about notice and things of that nature, it's the occupant's responsibility to place a notice at their entrance of their residence to either invite or prohibit someone from soliciting on their property. And this is the issue as it relates to what should be on that notice. And it should indicate that it says no solicitors invited. A way for our residents to indicate to somebody that's approaching their principal trends. Post these, and we have them available at the police department. And in our ordinance, it says that such a card or a sticker that's placed on the principal entrance exhibited will constitute sufficient notice that any solicitor of the determination of the occupant of the residence, meaning that they would not want them to bother them or knock on the door or otherwise attempt to get their attention. I put this up here for some comedic relief because the no solicitor invited sign is a sign that we give out at the police department. It has our number on it in case someone wants to call us if there's a violation of the solicitor ordinance. But the other thing is what myself, Administrator Reif, and Mike Walsh found on one of the doors along the river when we were going door to door telling them that it was getting ready to flood. And I will tell you that at our pancake breakfast, they appreciated it as well. And it's basically what I think everyone thinks, right? That, you know, when I don't want to buy anything, I already found Jesus. I know I'm voting for. If you're selling Thin Mints, I'll answer the door. Otherwise, leave me alone. Time limits, we spoke about this before, that in our ordinance, it indicates that you can't solicit
9 a.m. or after 8 p.m. on weekends or Saturdays, or at any time on Sunday or on a state or national holiday. So any questions related to the ordinance that
I've just kind of reviewed. Okay, now I'm going to talk about some of the court decisions that kind of complicate matters as it relates to solicitors. And I'll tell you that sometimes, in police work, the Constitution gets in the way. And in this particular case, that's going to be true as well, is that there are going to be some issues or some things that have already been addressed by the courts in regards to limiting the ability, or at least defining in the courts what they believe is constitutional versus unconstitutional behavior. Here's that first case I was talking to you about. This is what I was talking about in regards to a group of people that were subscriptions, and they were cited under this ordinance, and then it went to the Supreme Court, or Illinois Supreme Court in 1961, and you can see some of the excerpts out of the decision that I found there, and basically the ordinance is nonetheless invalid because the Illinois Constitution guarantees free speech, free press are broader in sweep than those in the federal Constitution. So in Illinois, we've granted even more latitude as it relates to the freedom of speech and the freedom of press. This one, and I may ask for a little bit of help as it relates to this one from our council, but this is Watchtower Bible versus the Village of Stratton, and this is really related to religious information. I wouldn't even call soliciting, but religious information, and the requirement at that time that all solicitors would have to register in this particular town. And I believe that in this case, it was that the courts found that, and it went to the United States Supreme Court, that the courts found that the village could not require those individuals involved in religious information, distribution to require them to register. Did you have anything? I got that about right?
When you say solicitation, that's right. This case distinguished these activities. Proselytizing was the word they used for the individuals that were expressing their religious beliefs on a door-to-door basis. And the court went on to include political speech without selling anything associated with that speech. Same thing with the religious proselytizing. And in this case, they highlighted the activity. So if someone were to put something on your car, your windshield, on your doorstep, without a face-to-face interaction, whether that's a solicitation, selling something or not, that activity is also absolutely protected from governmental regulation. A permitting process, a license.
It occurs in 2002, and it was pretty groundbreaking as it related to solicitors.
A lot of ordinances were changed in 2003 after that case. So.
There's also, it's not 2980, by the way, it's 1980 as a decision. So I didn't forecast in the future that this is a decision that will be made. Sorry about that. But this is the Village of Schaumburg versus Citizens for a Better Environment. And they tried to define charitable organizations and the amount or percentage of those proceeds that had to be used for certain charitable purposes, and defined it that way. They also indicate in this decision that the use of a no solicitor invited sign is a less intrusive and more effective manner in protecting privacy. So, and this is a 1980 case. I liked, and if you, anytime you can bring Greek mythology into a legal argument, it's great. And Justice Rehnquist talks about Sisyphus. And anyone, I put it in here so that you guys could read it, and it's from Wikipedia, so it's not a cited source, but basically it was effort and futility, where Sisyphus had to roll up a boulder up the hill, and then it would never get up to the top and it would roll down and you have to do that over and over and over again. So that's what Justice Rehnquist said about trying to regulate this type of activity, that it's very hard to do. I think that's what he was trying to say. And then we come to a more recent information that I received about 3 or 4 weeks ago from Julie Tappendorf, and that was both the City of Watseka versus the Illinois Public Action Council and Citizens Action Coalition of Indiana versus the town of Yorktown, Indiana. These are specific to regulating time and time that you can that you have to allow the availability for those soliciting for these purposes to use. So in particular, Watseka, which is an Illinois town, they wanted to limit soliciting between 9 and 5. And the IPAC, the Illinois Public Action Council, they wanted to solicit between 4 p.m. and 9 p.m. because they knew that people would be home at that time and they wanted to have contact with people at their residences. And what the decision was in this particular instance was that it's a First Amendment protection for door-to-door solicitors. And again, they come back to this issue related to policy, and that is that substituting the citizen's judgment in lieu of a citizen's judgment is inconsistent with their declared policy. So they had a very similar policy statement in their ordinance that we have, and they were indicating that it's really the resident that makes that determination. And in this particular instance, in the decision that I read, they indicate that the resident or the citizen can put the sign up and then take it down. So if they want to invite people during certain times, they could do that. And then when they're having dinner, they can place it up to keep, someone from disturbing their, business as it relates to that. So a complete ban on soliciting during those specific hours in this particular decision was found unconstitutional. The Citizen Action Coalition instance, it cites the Watseka decision, number 1. It was summary judgment, which means that I believe the court made that decision, and that the town actually cited both privacy concerns and safety concerns of both residents and those that were soliciting, because they had restricted soliciting to periods after sundown. So we had spoke about that when we were talking about regulating hours that we would allow people to solicit, and they basically said that that was not, that was constitutional muster as well, because the ordinance
It's tailored to meet a legitimate government interest, nor does it provide an ample alternate method for people to be contacted.
So we come down to this 4-prong test in regards to the ordinance, and these are what we have to address when we look at these solicitor ordinances and any changes there too, and that is that it has to be content neutral, it has to serve a legitimate governmental objective, it has to leave open ample alternative channels of communication, and it has to be narrowly tailored to serve the governmental objective, which means it can't be overly broad. So that's all I had to present. I don't know if Mr. Euler has anything additional to add to that.
Not yet, but I assume if there are issues or questions that come up that we may need to discuss this a bit further.
Just for the, could you go back to that last slide? Scott, could you briefly touch on all 4 of these and what defines all those, just so we have a better understanding?
Well, so let's use some practical examples. The first prong, that the regulation is content neutral, I think what most of us may be most familiar with is those activities that we would not object to if someone came to our door and tried to sell us something or talk to us about something. For example, our next door neighbor's running for office, and they're going to canvass the neighborhood. They're going to walk our street, knock on our doors, and solicit our support. Most of us would not object to that particular intrusion, assuming it's not too late in the day. But for us to meet face-to-face with a stranger that we don't know, or to have somebody come to our front door to sell something that we're not interested in is more annoying. The other content neutral activity we're all familiar with is Girl Scout cookies. We can't wait for the Girl Scout cookies to get to our front door. And that is generally not an objectionable activity, but this test is suggesting to us that we can't pick the activity. We can't pick the Girl Scouts being on our front doorstep or the commercial solicitor being on our front doorstep is speech. There is a content to each of those activities. Each one of those activities has a speech content. So we're not allowed to pick and choose which of those we're going to regulate. We regulate them all evenly, not based on content. So in an ideal world, it would only be Girl Scout cookies, our next door neighbor running for office, but that's not how the First Amendment works. It protects all speech. Serves a legitimate governmental objective. So the
Can I
last.
stop you for a second, just on
Sure.
number one? So if we had a time restriction, that would, content being neutral, it would meet that objective, right?
Correct.
Okay, all right.
Yes, it passes number one, but it may not pass some of the others, but clearly that's content neutral.
Okay.
And it's one of the reasons that that's one of the regulations we see most often in these cases as a municipal attempt to reasonably address solicitation. So serves a legitimate governmental objective. This actually, in the cases, is not exactly the standard. It really needs to be a substantial governmental interest that we're proposing to protect. So the problem that arises here with showing that we have a proper governmental objective is it can't be based on our assumption of a particular problem. So most of the regulations that we see challenged in these cases are based on, and I don't deny that I don't like people coming to my front door by and large, most people don't, are based on our concern about opening the door, for example, after dark to somebody. Somebody we don't know comes to the front door at 8 o'clock at night, knocks on the front door for whatever purpose, whatever solicitor's purpose. That would make most of us uncomfortable, I think. But the courts require us to establish that if in fact we have an objective that we're trying to achieve with a particular regulation, that we have to show that there's a problem. And we have to show that problem with evidence. It can't just be conjecture. It can't just be undifferentiated fear that we'd rather not have somebody there after dark as opposed to earlier in the day. So if we have evidence of a problem, a legitimate governmental objective would be, for example, you have a storm in town in the next week, next 2 weeks. You have a stream of solicitors in town that are selling new roofs, new shingles, and you experience massive fraud from those contractors, whoever they are. And they're moving door to door. And the police department finds out, the village finds out that we're experiencing more and more complaints about fraudulent activity. You have the ability to address that with evidence that you're seeing fraudulent activity from solicitors in town. You can regulate that. That is a legitimate governmental objective that's based on evidence of a problem. So does that make sense for number 1 and 2?
What if it's a bunch of residents who don't want it? Is that a legitimate government objective? So if you had half of the village of Cary that signed a petition that said we don't want this during these times?
That's a great question. Again, I think most of us would assume that we do not enjoy having people come to our front door unless it's the Girl Scouts. But the problem with that approach is the other interest that's being protected by the First Amendment under these circumstances is the right of an individual resident, whether that's one person or 2 people or 10 people or 100 people in town, their right to not be regulated by the village of Cary or any village, any government, telling them that they can or cannot allow somebody to come to their front door. So if we enact a regulation, it applies village-wide. It applies to every solicitor and every peddler and every canvasser that proposes to approach a home in town. And there can be people in town who do not want government regulating their choice of who can or cannot come to their front door. I know this is going to strike us all as odd because nobody enjoys these kinds of activities at their front door, but some of these activities are acceptable to people or approved by residents, and they may not mind certain people coming to their front door. So for government to step in and say, no, no one can come to your front door based on the village's decision, that's what's being protected here. And what the First Amendment does is it protects, you're all familiar with the example of the Nazis marching in Skokie. Nobody is in favor of that activity. And if we could, we'd make an exception to the First Amendment and say, nope, not for that activity. That one is just too objectionable. But by protecting that activity, we protect all speech in all circumstances. It shows to what lengths we go to protect that particularly profound right that we have as Americans. So that's number one. Number two. Number three, leaves open ample alternative channels of communication. So if you ban an individual who wants to communicate about a political issue, their candidacy, the Girl Scouts wanting to sell cookies, if you ban them from going door to door or restrict that activity, there aren't very many other channels of communication that they can pursue. A door-to-door solicitation is a core contact for certain kinds of solicitation, certain kinds of speech. So this one is kind of hard to meet when we regulate or especially we prohibit an activity like door-to-door. So let's say our hours were limited to weekends for solicitation. So this particular prong would be particularly problematic because we would be limiting to such a great extent that full week of time that people would have to go door to door to share whatever message it is they want to share or to solicit particular products. And the last one is narrowly tailored. You don't, in any regulation or with any regulation by a municipality, this particular prong of the test means we can't sweep in more speech, protected speech, than we absolutely have to. So if we're trying to address fraudulent activity by contractors after a storm to fix roofs, that particular regulation would be geared to that fraudulent solicitation. It would not be a general 6 o'clock ban, 5 o'clock ban, 4 o'clock ban on all solicitation, because we think we have a particular class of solicitors that's causing a problem in town. It would need to be narrowly tailored to address that problem. Okay?
Okay. So now we have some groundwork. We'll have some discussion about it. Can I ask a question about the charitable? Are the Boy Scouts or Girl Scouts, are they considered a charitable organization? Because it's a non-for-profit kind of a thing? Are they not-for-profit?
They are non-commercial. In this realm, the distinction that's generally made is a commercial for-profit enterprise or a non-commercial activity. And that would cover a charitable group like the Girl Scouts.
Okay, so they would be exempt from any type of ordinance then?
No,
No?
no, I mean, it depends on,
Did I get that backwards? I think I did.
it depends on the
I want my
regulation. We have less authority to address non-commercial, so here's how the continuum goes. If it is pure speech, no one is selling anything. They're just, they want to talk to you about their particular cause, whatever that might be. That enjoys the highest level of protection, and we are limited to the greatest extent our ability to regulate in that area, pure speech. If we then move to a charitable group, non-commercial entity that is still engaging in free speech of some kind, but accepts donations. Some religious groups do, some charitable groups do. That's the next layer of protection. They have the next highest degree of protection under the First Amendment because it's not a commercial activity. And you enjoy a little bit more power or authority to regulate in that area. And then commercial solicitation is the last one.
Okay.
And you can regulate to the greatest extent there, even though there is still protection under the First Amendment. Commercial solicitation is considered to be speech under the First Amendment.
Okay. Any other discussion?
Well, so there are different times that exist for different ordinances. So what would meet all those 4 prongs? Like what is that magic time?
Okay, here's the answer you're not going to like, and I don't particularly care for myself, because I share your view that door-to-door solicitation seems largely like a thing of the past. But it is still with us. It's still protected as speech under the First Amendment. Any of these restrictions that are based on time, that are based on a 5 o'clock, 6 o'clock, 7 o'clock time limit, as the chief already indicated, the courts look at the prime time for an individual who wants to exercise their free speech rights as the time that we get home from work. That's when people are in their houses. That's when the adults are home. So if we had a limitation, for example, that started at 5, you can't solicit past 5, that essentially eliminates the most meaningful time for free speech to be exercised in this area anywhere. So that would be the most restrictive hours we could put in place, 5 o'clock. Can't solicit after 5. While I recognize and I would support 5 o'clock just as a resident in my village, the courts have looked at that sort of restriction and said that can't work unless you have evidence that there is a problem occurring in your municipality that you need to address with a time limitation. That can be done based on evidence. It'd be very difficult to show, but in fact, if we have police records of a particular activity in town that is based on fraud, is based on criminal activity, is, after dark, we're seeing more criminal activity from individuals posing as canvassers, solicitors, salespeople, whatever it is, and you can show there is an increase after that period of time, and that's the activity that's causing the problem, we can address that with an hour restriction. We can address that with increased licensing requirements, permitting requirements, whatever that might be, criminal background checks. But an hour restriction, and so I'll go to the other end of this hour restriction. What is acceptable under all the cases? 9 o'clock at night has been recognized by all the cases. I mean, that seems extreme. We're putting our kids to bed generally before 9 o'clock at night. And we don't want somebody at the front door ringing the doorbell and waking up the dogs. So 9 o'clock has been universally recognized as a point in time that's acceptable, and that can serve as a reasonable regulation. So that really leaves us, I think, with an hour, a time restriction somewhere between, that time after 5 o'clock, 6 o'clock, 7 o'clock, and 9 o'clock as a reasonable time limitation to set for these kinds of activities. The reason the cases say what they do, and the chief has already highlighted this, to the courts, we have a protection in place that's available in every town, in every city, in every village in the United States that is absolutely ironclad and protects every resident in every village across our country. And that is, you put a sticker on your front window that says no solicitors. That's in every one of these cases. That is the least restrictive, most narrowly tailored, specific limitation on invading a resident's privacy that any village could put in place. And it's available to us all. That and you don't have to answer your door. The courts point to those two issues, those two elements, as the ultimate protections of an individual's right to choose. Your ordinance says you leave it up to the individual to decide if somebody can come to their front door or not. The way to do that is you either put a sticker on your front window or you don't, or on your front door, and you decide.
Now, what if a, let's say a homeowners association wanted to do something for the entire association? Could they put a sign up at the front of?
That's a good question. That's an excellent question. So we have some cases, Pat didn't talk about these cases, but there are towns that have tried to approach this as a municipal regulation matter where you can register with your town, your village, your city, and say, I want to be on the no solicitation list. Okay, and then the city keeps a master list. In those regulatory schemes, the idea was that you would require people to come and get the list. And you'd know ahead of time, don't even walk up to that house. They're on the list, they're on the no solicitation list, so don't bother that homeowner or those residents. So in that case, if a subdivision, collectively, everybody in the subdivision said, we don't want solicitation in the subdivision, I mean, other than having a gated community where you win because you have your gate out in front, you could certainly say, nobody should be walking these streets engaging in solicitation activities because everybody's already decided you can't come to the door.
So that
So
would
that's
be,
a clever, that's a creative,
that could be enforceable then, right?
yes,
From,
assuming everybody's on board.
so it has to be 100% participation or
Yep.
just a majority?
Because you couldn't, and let's,
If one person's a holdout, you couldn't do it because you're
right.
interfering with
And-
their,
And that, in our country, as we all know from high school civics, we do not allow a tyranny in our country by the majority. So the majority of us cannot decide to interfere with the rights of anybody else that may have rights under the Constitution. So if one person, believe it or not, in a subdivision said, I don't mind people coming to my front door, I'm not going to sign up. There's always one of those who's contrary. If there was one person, then we wouldn't be able to say you can't enter this street and enter this subdivision for these purposes.
So even though Northwood Acres is not in the Village of Cary, they do have that posted in the front of their subdivision.
And then it also goes with Boy Scout, Girl Scouts are not allowed then to be in that subdivision selling anything too. If,
Correct, unless, now this all comes back to the individual choices of homeowners. A homeowner always has the ability to say,
except,
I like Girl Scouts, I don't like anybody else. They're not a governmental entity. We don't regulate private citizens under the United States Constitution. We regulate government behavior. So government doesn't take away rights or choices that we have unless we can satisfy the standards that have to be satisfied to interfere with somebody's First Amendment freedom. So yes, you can still buy Girl Scout cookies in that subdivision if you chose to.
But you're inviting them in, the
Somebody
homeowners
has
to
to go out
invite
and
them.
stand at the front of the subdivision, wave them in. You can't keep them out. Don't worry, they'll get in there.
So since we're looking possibly in the past at getting new signs in Cary, welcome to Cary, no solicitors. I'm just kidding.
Beware,
Beware, right.
go no further.
well, does anybody else have anything they want to say? I mean, I don't think anybody here on this board is a big fan of solicitors. I think that, we're trying to look at something that's going to be realistic, that's going to not cause us any strife moving forward. You read these lawsuits and things, and it's pretty cut and dry what the regulations are. So what is it's been talked about making it 5 o'clock, 7 o'clock, 6 o'clock, 8 o'clock. What keeps us the most out of trouble? That we're not imposing on anybody's freedom of speech or right to solicit?
9 o'clock, but that's pretty late. I would say 8 o'clock is still defensible. You can have, as the chief has indicated, for commercial activities and even for some activities that involve non-commercial activities, that involve donations or some solicitation of funds, you can have permitting requirements, licensing requirements, criminal background check requirements. If those individuals don't abide by your rules in their activities in the village, they can be banned from continuing to engage in those activities. For pure speech activities, somebody coming to your front door with a religious message that they want to carry across the land, that is not subject to, under these cases, to much more regulation from a governmental entity other than putting a sticker on your front window that says no solicitors. And not opening your front door, saying I'm not interested in talking to you.
And I think, to kind of dovetail on Mr. Euler's assertion here that there has to be a problem, that's why I gave you some statistics in the beginning, because we're talking 40 to 50 complaints a year and less than 5 or 6 violations that we find that we can cite a year. So if that was the basis for our regulation or our restriction, I don't think that would be viewed very favorably. I just, what we need is for people to call us, and then when we go out, people that are interested in being witnesses to say that they did come to my door and that they come to our administrative, or our administrative hearings when we cite people for the violation of the soliciting ordinance. But that's very difficult to do. I will tell you, that's very difficult to do.
So I found some towns that had a 7 o'clock ordinance.
Yeah, there are. If you were to look at ordinances in the area, just take a sampling of 10 towns, I think you could probably find at least one thing wrong with most of those ordinances.
And I will tell you that Lake County has a 7 o'clock ordinance.
Has what?
Lake County has 7 o'clock. It's theirs is from 11 a.m. to 7 p.m.
Now, the 7 o'clock is supposed to be justified. That 7 o'clock is more important than 8. So if in fact you were challenged, you'd be asked to explain why 7 o'clock, not 8. So there needs to be some governmental justification for that time that you're going to land on, 7:30, 7:45, 8 o'clock, whatever it is. And it could be, as you get to 8 o'clock, it could be kids go to bed. Kids, that's the time when people are not up, not able to answer a door. 8 o'clock still seems like it's in a pretty defensible range to me. And then 7 o'clock seems like it would be more vulnerable to a challenge. And I can't tell you what the result necessarily would be. Part of it would depend on your justification for the restriction. We can't put any restriction in place unless we can explain
Justify it.
what the interest is that we are regulating by putting that in place.
So we had a resident send us an email, and he said that less than 9% of the people asking for petitions were actual Cary businesses. Some of them didn't have addresses, so we kind of just gave the benefit of the doubt and said, hey, maybe these are Cary residents, so it's less than 9% of actual Cary businesses over the past 3 years. The other thing that I thought was interesting is that that resident also said that only 2 Boy Scout troops went ahead and got solicitor's permits. And you had explained to us in the past that you guys are reactive. So you're not seeking out to go ahead and, ask people when they're going around, hey, where's your permit and things like that. It has to be an actual complaint from a resident. So as you can kind of see, Boy Scouts, Girl Scouts, Cary Youth Baseball, whoever's selling something hasn't been the target of really pushing to get a permit. So I'm not concerned about the Boy Scouts and Girl Scouts not being able to sell, since it has to be somebody actually complaining, hey, a Girl Scout rang my doorbell and where's their permit? So I actually am starting to
Only takes one stone.
It does, you're right.
Yeah.
But I'm actually starting to go back and think, you know what, since I've learned so much since this whole thing, I wouldn't mind going ahead and having background checks done again and talking and going just the other way now, because if we can't limit the time, we can at least limit the people that do come to our door, make sure they're safe. And we have people that are answering the door that are maybe single parents, maybe they're elderly people. I just feel that it's a safety issue. And so I'm actually starting to think the opposite way. And again, not everybody's getting a permit that's supposed to. And again, it's a reactive thing. So I don't think it's really going to affect the Girl Scouts, the Boy Scouts, the Cary Youth Baseball, any of those organizations. I could be wrong, but that's my opinion.
Oh, and I will also tell you that in my experience here in the community, that anecdotally I've seen a different type of soliciting for the Girl Scouts and the Girl Scouts cookies particularly, and they kind of have a pop-up, stand
Right.
where people go to them versus going to the door-to-door. And certainly I think that part of that might be a safety for the solicitor, for the juvenile solicitor themselves, but it also serves a purpose that you're no longer, invading someone's privacy for this. They're coming to you for that sale or at the stores, because they tend to use the storefronts a lot, especially for Boy Scout popcorn and Girl Scout cookies.
Yeah, I've always liked that ordinance that we had a few months back with background checks. I thought that was really good. And if the times we can't restrict those, I certainly would like us to at least revisit those background checks. And like I mentioned before, I still really like the vests where somebody walking up to a door, a resident, if they're looking out the window, they can see who that person is and identify that person right away as somebody who's permitted within the village of Cary.
Can I just clarify? I know some of this may be semantics, but when you say we can't have a time restriction, you can have a time restriction. You can have, and this may not be the most comfortable solution for everybody, but you can put a sticker on your front window that says you can never come to my front door, and that's enforceable. That is a time restriction. It is a 24/7 time restriction.
I get that, and I have that on my door.
Yeah.
We still get people, obviously, at our door, and I know that.
So then
even
the
if you
issue
call the
becomes
police,
enforcement, yeah.
By the time they get there, a lot of times they're gone from the
Yeah.
area, and then they're kind of circling around, and after a while, they're gone.
Right.
By the time the police arrives. So a lot of those don't get cited or anything else, and then you have to wait for the next person to maybe call.
Right.
But a lot of times, like I know the chief said, then you need the complainant to actually show up to either court or the adjudication hearing. So all these things need to kind of line up for there to be, police enforcement and everything else. So I'm just trying to think of a way that we can just protect the residents and, hopefully solve this issue and move forward, get past it.
I'm going to pose a question to Mr. Euler as well. And you mentioned background checks, reasonable fees for permits.
The greater the fee, the greater the restriction on somebody's First Amendment freedom. License fees generally are not, unless it's a commercial solicitation activity, they generally are not permissible. You can require a permit, but once you get into licensing fees, that is a more significant governmental regulation.
The governmental unit could recoup their costs for those fees, though. But we have to be able
That's what the
to
licensing would
justify
do, right?
our expenditures.
Yep.
Right. And we had talked about that too. I think I've always been a proponent of making sure that every person that shows up at a door has some sort of a license or permit that says that they've been vetted through the village of Cary. And there's been time and time when people show up at my front door and I said, do you have a permit? Oh, my manager's got the permit. Well, you know what? We need to, in order to have enforcement, you have to have control measures in place. So our ordinance needs to control what's going to happen so that we can enforce it properly. So, I mean, I don't recall reading in the ordinance that every person going to the door has to have a permit or a license with them on their person?
Yeah, well, yeah, actually, it does have to be on your person. And the way our current ordinance reads is that it says every person desiring to engage in soliciting has to submit themselves to a permitting process.
But it doesn't say that they have to have that license on
Well,
them.
actually, let's see if I have it here.
Does it?
Yeah, you know what, I don't have it on here, though. I'm sorry, but there is a requirement that they have to carry it.
Because, I've said, you need to have a permit on you. And, well, it's always the manager, or their leader, or whatever has the permit. So, if this is the way it's going to be, we have it, I'm honest, we don't answer our door anymore at night. It's just, no kids at home. Nobody wants to play in our backyard. No one wants our kids to come out and play. Our friends call us on our cell phones. And so we just don't answer the phone. Or that too. We say caller ID on the doors, but it's we're sheltering ourselves. Yeah, no, but I understand. We have to have some controls in place that we could make sure that we can enforce this in a timely manner. If somebody shows up at the door and they're not wanted, they don't have right registration. When somebody calls the police, they should be able to respond to something. We haven't heard much from the left side here. Any comments?
It seems pretty clear cut, what we can and can't do. I'm not in favor of fees. I don't like that. I'd be in favor of the vest. Background checks, how much does that cost and who would cover that cost?
The fees.
But I mean,
Yeah.
if I came to the village and wanted a permit and they did a background check on me, who pays that? Do I pay that or would the village cover that cost?
It depends on the type of background check that we want to conduct. We can conduct, certain checks through the Bureau of Identification, but it's a fee applicant based, and criminal justice agencies get more information than those type of responses. We would only get convictions versus arrests and convictions on the criminal justice side. So, and then we just did this for all of our tow operators. we ran all of the tow operators through a background check because you can statutorily now, and that was $27 a person.
And if, let's say, a Boy Scout, Girl Scout troop wanted to, did you say in the past, like, one leader could go ahead and get it for the whole
Well,
troop?
that was the way we had written that original amendment to this ordinance was,
Okay.
instead of having all the, people that would be doing solicitation, we would have one person responsible for it. So they would be the only person that had the register, and then they would be responsible for the group that was soliciting on their behalf.
So with those little Girl Scouts or Boy Scouts selling wreaths, would they have to have a permit on them when they're going door to door?
We wouldn't be able to because in our original concept here, it would have just been the person that makes application. So they wouldn't have, we could. I think that was kind of something that we didn't want to do or we found repulsive in regards to taking their photos and what do we do with their photos afterwards and things of that nature.
Well, perhaps we can come up with some sort of a form or permit or something that just for the youth to do, even like the high schoolers that show up at our door selling coupons and that kind of stuff. How do we regulate that? Again, we don't want selective enforcement here. We want to make sure that everybody plays on the same rules. We know exactly what we're working on. So everybody on this board can defend what our ordinance says and say, well, these are the rules you have to play by, and this is what you have to do. And, I've sent people that have showed up at my door. You've got to go to Village Hall, you've got to fill out an application, and then you can do what you're doing.
Yeah, well, what we can't do is be disparate. So we can't say that it's okay for Girl Scouts from Cary to solicit, but then Girl Scouts from Lake and the Hills can't. Once you allow it, I think it has to be pretty much universal.
So, and what I heard too, I think, is with commercial solicitors, we can charge a higher fee than, let's say, like a non-for-profit organization like the school selling those, whatever those, the discount cards. Because obviously that's getting donated back to the school or to some parent-teacher organization or whatever it is, giving it back to, versus somebody who's just profiting.
Right, so you wouldn't want the fee to create any kind of a chilling effect or impact on the activity itself. So if they're selling the coupon books at the high school and the parents say, well, look, I'm not going to go pay out of my own pocket a licensing fee so I can go with my son or daughter and sell the coupon books, I'm not interested. If it has that impact or effect, it's a regulation that probably is impermissible.
Okay.
Which is, I think, what it would be. I can't imagine parents saying, hey, you got to go do a fundraiser, go register and pay $27 so you can go raise money for your school or for your Boy Scouts or for.
But we
anything
can
like
put an
that.
exception to that we don't have to charge for them then?
If you're going to charge a licensing fee, yes, it could be related to the nature of the activity, potentially. If somebody is selling a significant amount of goods in some fashion, a licensing fee is not going to impact their desire or willingness to solicit.
So would that be, if someone gets it every 12, like Chief was saying, there are some solicitors that do it every single month. Are we charging them a fee every single month when we issue them a permit? Are we doing it once a year? Are we doing it the first time only?
That would have to be in your ordinance.
Right, we'd have to make that determination in regards to what our comfort level is in regards to background check and when they become stale, right? Yeah, that's what we're really talking about,
Yeah.
is when the background check becomes stale.
So we're saying that you could go ahead and you could say, okay, these organizations, we're not going to charge a fee to, but these other ones, like, let's just take one of the ones that I think is pretty annoying to people, and that's the utilities that come around, right? That come out and solicit. So we're going to say, we're going to charge you, but then let's say that we have a home remodeler, and how do we know what they're, who decides whether they're making enough money to have to be charged or not charged? What's the criteria?
I would hope that if their life depends on, their income depends on making enough money to live, that they're spending all day soliciting and they need to do it, all the time. I would hope that they're making enough money to go ahead and
I understand, I respect what you're saying. I'm just saying, how do we, it still begs the question, how do we decide? Is it just only youth organizations or non-for-profits that we don't charge and then everyone else is? I mean, I just think we need to have something set,
Right.
you know, so that it's not, someone can't say we're doing disparate treatment, we're discriminating, we're, you know, treating one group differently than another group. That would be my concern with regulating it, that's all.
Right. Same thing with criminal background checks. You have to decide
Right.
if all the parents selling coupon books, and they're not, but they're going to be subject to criminal background checks. There would have to be some distinctions about what activities would be covered with that.
And I think in our ordinance that we submit, there would be a sponsor. So you would designate a sponsor for this activity, and they would be the person that had to be subjected to that type of background check.
And then it's a question of educating. We'd have to make sure that everyone knows that, because, you know, schools, a lot of times when they're doing different things or different organizations, we'd have to make sure we outreach and got that out to everybody.
It's kind of interesting that you say that, because right now, everybody's supposed to go and get a permit, no matter what. Girl Scouts, Boy Scouts, yes, if they're selling something to your door. So for us to make sure that everybody knows about this, everybody's supposed to already know about this. They just don't do it. So it's kind of interesting that you're like, oh, we got to make sure that, you know, everybody knows about this. And I just find it interesting, because I feel like you're trying to make a bigger deal out of this than it is with regard to Boy Scouts and Girl Scouts and fundraising.
Absolutely not. What I'm talking about is if we're going to change it and make it so that people are going to be subject to a fee or get a background check. That's what I'm
We can
talking
go
about,
ahead
that
and
they need to.
exclude, though, from what I understand, like fundraisers or non-for-profits or things like that. Is that what our attorney is saying?
Relative to a licensing or permitting process,
Yes.
yes, you could create, I think, a specialized, especially if you're dealing with minors, the need for a criminal background check or intensive licensing background process is vitiated if they're minors, so.
And we do have two separate soliciting ordinances, so everyone knows. There's a charitable and then a regular soliciting ordinance. So it may require some clarification on both of those to make a clear distinction between what is a commercial activity and what is not a commercial activity. For example, you know, I'm a member of the AMBETS. There's 503 C19. We have been recognized by the Illinois Attorney General's office to be a charitable organization.
Right.
I don't know what the answer
Fall
is,
under that category.
Under that category, yeah.
but, you know, there's some manners of certification that you can maybe rely on in regards to these issues.
So that is something that we'd have to talk about in another term. Right now, we're talking about soliciting ordinance, and I think we've kind of come to our decision on that, right? With
Well, we
the
can't
time and
regulate
stuff
the
like
time.
that.
We can control
So-
the solicitors more than we can with their time, with background checks and permitting and. So based on what you've heard here, what would your recommendations be?
I think we'll dust off the original proposal and probably, you know, maybe modify it a little bit as it relates to some of the issues that we discussed here. And of course, I would have our esteemed counsel take a look at it before I ever submitted it to you. So I think it would have to be amended a little bit.
All right, so just to correct me if I'm wrong, but I'm thinking it was pretty cut and dry, but the only thing that we really didn't like was the fact that of photographing the youth.
Right.
So if we can come up with a
Alternative?
alternative for that category, we would be okay for that. And keeping the ordinance as it is with from 9 to 8, so it keeps us out of hot water that way, but then we could control it by having these other factors in place without.
Still restrict it, from what I understand, previous to 8, that Lake County does it, and I would like to still push it back as early as we can.
And I think, you know, some of the discussions in the case law, and Mr. Euler, correct me if I'm wrong, but they really like the time period between 6 and 8 p.m. They really like that time period.
Who's they? The solicitors?
No, the courts.
They find that
Both, I
it's
guess
more
both. I guess
appealing
both,
for the
but-
solicitors to be able to have between 6 and 8.
We don't know if the judges live in gated communities and they don't have this problem. But the courts, they were pretty uniform on that issue.
Okay, so there's been no court cases in Lake County? Where,
Actually, there are. In fact, one is in the Seventh Circuit, and we're part of the Seventh Circuit, so it would absolutely apply to us.
and then just out of curiosity, and I know nobody can probably answer this, but our previous legal firm didn't update us on any of the stuff when it came up for vote last time.
Oh, that's
Regard
not,
the
that's
hours.
not necessarily true. Julie Tappendorf did give me some cases that were probably 2 or 3 weeks ago, and it was specific to Watseka and Yorktown. You know,
I
she
mean,
she
the
did
meeting
some
that I had
research and she gave it
missed.
to me.
With regard to the meeting I had missed for the vote at 5 PM, ending time.
I'm surprised she didn't bring it up.
It was
No,
never
you know what,
brought up.
I don't recall, I don't believe that she had, given that information to me prior to that.
Are there any other comments about this? Can you dust off that last ordinance and kind of interject some of the
Sure.
thought process that we have here? Would that be conducive to everybody and we could bring that back to another committee? I'm thinking maybe probably the second meeting of, Jake's not, probably second meeting in May or maybe first meeting of June. We have got a lot going on first meeting of May. So I don't think that we would dive into that right away. Is that suitable for?
We have to give Mr. Euler some time to take a look at it as well.
Does that mean with everybody's approval?
That's fine with me.
I think that's great.
Okay. All right, Chief, well done on your PowerPoint. Excellent, thank you.
Just
Thank you
trying
for
to
your
meet-
input, Scott. Now I can't wait to see what Eric's going to do the next time. Okay, I will entertain a motion to adjourn.
So moved.
Second.
All in favor?
Aye.
Opposed? We're adjourned.